Imagine thinking you can outsmart the courtroom, only to have the system shut you down at every turn. In this video, we witness two intense courtroom battles where defendants try everything to avoid the consequences of their actions, and it doesn't go their way. The first case shows a man facing 2 life sentences. Instead of working with his lawyer on a plea deal that could save him decades, he claims he can't read, can't write, and doesn't understand what's happening in court. He tries to represent himself, thinking he can manipulate the system, but the judge sees right through it. The courtroom tension rises as the judge refuses his self-representation and moves forward with the trial, leaving him with no shortcuts or tricks. In the second case, another defendant repeatedly demands a bond hearing, even though his bond was revoked after committing another crime while out on release. The judge calmly but firmly explains why the bond can't be reinstated, emphasizing that bonds are a privilege, not a right. No amount of arguing, repetition, or stalling changes the reality. The court's decisions stand. This video is a fascinating look at what happens when people try to bend the rules of the legal system. It's not just about the law, it's about the limits of courtroom manipulation, and how ignoring procedure or pretending ignorance rarely works. Stay tuned, because these hearings are a masterclass in patience, authority, and the hard truths of justice.
Finish knowledge.
Yes, sir.
So I would like to put a few things on the record, Your Honor. My client had an offer from the state last week, and he did not wish to take advantage of that offer. My investigator and I went out to the jail, talked to him, went over things, explained everything to him. I gave him my advice, which was that I thought it was in his best interest to accept the offer. He refused that, and that offer was for 20 years with a mandatory minimum. He still has an offer today for 25 years mandatory minimum, and I've discussed it with him briefly over here in the box, and he's told me that he doesn't wish to do that. But considering the
Hey,
fact,
Your Honor, this man ain't even helped me in my
Marty,
defense. None of that.
Mr. McCarty, I told you I'd give you an opportunity to speak.
Okay. Yes, sir. Yes, sir.
Finish.
what I was going to say, Your Honor, is considering, I've explained to him that his exposure is in the 3365. The attempted murder case is a life sentence, in that he's further exposed in the 2756 case on the tampering to an additional 30 years, since it was a tampering with the underlying case being a first degree. So I've explained to him his exposure. I've given him my advice. I've told him what I think is best for him. And he, as is his right, he's choosing not to do that. But I did want that on the record so that there was no confusion later on about whether or not I had informed him of the offers and how I advised him and that sort of thing. So,
Your Honor, my intention is to revoke those offers today, and I plan on moving forward next week. One thing that Mr. Williams mentioned, yesterday I filed the HBFO notice, which actually extends his exposure in the tampering case from 30 years to possible life in that case as well. Okay. So the maximum that Mr. Cromartie faces is 2 life sentences consecutive.
Okay. I really wasn't aware of that. Do you hear what he said?
Yes, sir. But
so let me ask you this. Before the judge is going to give you a chance to talk.
Okay.
But in light of the fact that Mr. Sullivan has made this new filing, and now you have your maximum exposure is 2 life sentences, do you wish to reconsider your choices with regard to accepting the offer?
I don't understand. I don't understand. And being him, being that he's representing me, we haven't even worked the defense in this case at all. Period.
Okay.
And plus,
let's take one thing. Do you understand that you've been off for 25 years in prison?
I don't understand, sir. Yeah.
Then yes, you do understand you have a plea offer for 25 years in prison.
I don't understand because I'm innocent. I don't know what's going on. I don't know what.
Listen, you've already you've entered a not guilty plea, so there's a presumption that you're innocent, or a presumption you're not guilty. So that, regardless of your claims or the fact that right now we presume you not guilty, you understand the state has offered to let you plead no contest to charges, and it'd be a 25-year sentence. And I believe, what is it? Is it a minimum mandatory 25?
It would be a minimum.
Minimum mandatory minus the time you served in jail. No, I just need to, you understand that's the plea offer from the state.
Hell no. I don't understand none of this, what he thought. And it's a conspiracy between these two right here.
Listen, Mr. Cromartie, what are you?
Man, I don't understand, sir.
I don't believe you, Mr. Cromartie, because what are you asking for right now? What are you asking for?
I'm asking for him to be removed off my case.
Raise your right hand to be sworn.
I do.
Wait till the oath is done, sir. Do it again, madam.
Yes, sir.
Raise your hand again.
Solemnly swear the testimony you're about to give is the truth.
Yes, ma'am.
All right, Mr. Cromartie, state your name.
Jamel Cromartie.
What are you asking for today, Mr. Cromartie?
This name of this contract does not refer nor identify the male standing in this corporation. I, Jamel Cromartie, being forced to go against my will and my best interest. My right of due process have been impeded upon. Also, my Fourth and Fifth Amendment right have been violated. I invoke my rights of the Constitution to protect me and my best interest. I invoke my Fifth Amendment.
Okay. All right, then you vote the Fifth Amendment right, so you're not asking to testify. What are you asking me to do?
First of all, I have the right to face my accuser.
Listen. What are you asking me to do today, Mr.
You
Cromartie?
saying I don't understand.
Mr. Cromartie, what are you asking me today? I'm gonna give you one.
I don't need him on my case.
Okay, are you listen, what are you asking me to do?
Or this one right here. This both them two right there.
Okay.
I got some that's conspiracy on what they trying to do.
Okay, what do you want me to do?
Continue my trial.
No, sir. Motion denied. What are you asking me to do? What are you asking me to do, Mr. Cromartie?
A fair trial.
All right, right now you're gonna get a fair trial. Is there anything you're asking me to do right now?
I'm saying I don't need them on my case.
What are you asking me to remove them?
Yes, sir.
And then are you gonna represent yourself, or are you gonna hire another attorney?
I'd rather represent myself to get an attorney.
You already sworn in, so state your name again.
Jamel Cromartie, sir.
Mr. Cromartie, you're asking to represent yourself next week. Is that correct?
Yes, sir.
Okay, you understand that you're looking at life in prison if convicted of two life sentences.
Okay.
You understand that?
Yes, sir.
Okay. Do you understand you've been offered a 25-year plea deal?
Yes, sir.
And when you said before you didn't understand that, you were not being truthful with the court. Is that correct?
I mean, I'm saying yes, sir, to say yes, sir. I'm guessing you're agreeing with me. I don't know.
No, I'm asking you a question. So you don't understand that. Is that correct?
Understand what?
That you have been offered 25 years in prison if you pled no contest, and that will settle your cases. Do you understand that?
I don't know how to answer that.
You're going to have to answer my questions if you want to represent yourself, sir. If not, I'm not going to find you competent to represent yourself.
Yes, sir.
Do you understand you've been offered 25 years in prison? Is that correct?
Yes, sir.
Okay. So when you said before you didn't understand that you were not being truthful with the court, is that
It's
correct?
a lot that's going on that I don't understand.
Listen to me.
Yes, sir.
You were not being truthful with the court. Is that correct?
I'm not gonna say I'm being truthful.
When you
I
said
don't understand.
you don't understand.
You got to talk to me in a level where I got to
Yes, sir.
understand.
I'm talking to you the same level.
But some of it I don't understand because there's some shit.
So you
that's
don't
going on.
you don't understand what's going on?
Half of it I don't.
How far did you get in school?
9th grade.
And you read and write?
Barely. I could barely spell.
Okay. And do you understand if you represented yourself, you'd have to do everything a lawyer
I'm gonna
did?
do what I can that I've been trying to do.
Do you understand you'd have to do
I do
everything?
better than him.
Listen to me. If you want to represent yourself, you've got to answer these questions. If not, I can't allow you to represent yourself. So
I ain't trying to make a fool of myself, but Yana, I don't need them two on my case.
okay. You can barely read and write. Is that correct?
I learned.
You're gonna pick a jury Monday morning. I'm not continuing the case. And you're gonna try the case next week if you represent yourself.
Okay.
And you read and write.
I'm gonna learn.
To learn. So you can barely read and write. Is that correct? You don't understand about the plea offer. You understand that lawyers are trained in the rules of evidence, criminal procedure, and the law. They're there to assist you in preparing for trial and trying the case. Do you understand that? Okay, well, I'm gonna find that you're not competent to represent yourself. Mr. Salim will stay on his case, Mr. Williams will stay on that case, and we'll see you Monday morning and pick a jury.
All right.
That's for the record, that's 23 CF 204.
Yeah, well, I got a couple motions I want to file on that one, but
Okay.
about that case, so can I ask why am I being held without bond?
Sir, before we've gone over that, I revoked your bond, I believe, in the K2 case numbers because of the arrest. So I think we've already adjudicated that and litigated that. All I'm gonna litigate it, but that's why you're being held without bond.
I mean, is there a reason though, sir? Like,
Yes, sir,
reason to
because
be held without bond?
yes, because you were out on bond and you picked up another charge.
But I'm innocent on that charge, Mr. Clark, and I got the evidence.
Absolutely, you're presumed innocent on all the charges. So I assume you're not admitting that you're guilty on the two charges that you're out on bond on. You're presumed innocent on all three of the charges.
Can I ask if the state has filed a motion to hold me without bond, Mr. Clark?
No, sir, I believe the court, I believe, and I may be wrong, I may have done it on my own motion.
You had a hearing in February, I believe it was February 24th, and then you addressed it also at our last hearing on October the 17th.
There was an order of revocation of release, and that was done by the first appearance judge on January 18th. So that judge held a hearing and revoked your bond, or issued basically a warrant and held you without bond. So that, and I upheld that.
Well, I understand, sir, but it's been since January. Is there a reason why you feel like I need to be held without bond?
Yes, sir, because you picked up another charge while you were out on bond.
Well, Mr. Clark, I'm just speaking real quick.
Go ahead, do it quick. Before we address that, Mr. Williams. I don't have to make it any plainer for you.
Have a little patience with me, sir. I understand that's judges. They should be patient with their client, with litigants.
Well, I'm as patient as you. I'm gonna be patient. I'm gonna treat you just like a lawyer, and I'm treating you just like a lawyer. And when a lawyer goes to repeating themselves or re-litigating something that's already been litigated, I give them very little short leash. And that's basically what I've done to you. I've addressed that so many times. I'm not prepared to address it again today. So if you want to talk about something else, let's move on. But I'm not going to reinstate your bond today. Okay? You picked up another charge while you were out on bond.
Well,
That
listen,
is just,
okay.
and that, I know that you say you're innocent, and you've said you're innocent on.
Listen, I just want to say this one thing, Mr. Clark. One thing, but we can move on to the next thing.
Okay.
Okay. What makes me different from the person that you released last month?
I don't know.
I picked up a driving on suspended license charge.
I got no idea.
He had battery on the police officer.
Listen to me. I'm not going to compare you to other.
Battery on the police officer.
I'm not going to compare you to other cases right now because I can't remember. It's not fair to me. I don't know why I did what I did.
I've been in jail. This case been going on.
Let's move on. I've answered your question. What else is there? Go ahead.
Sitting in jail for 3 years, Mr. Clark.
I understand, but tell me what else. No, you ain't sat in jail for 3 years. This was the.
Yeah, for a few months when I caught that BS charge, but I got a total time before 3 years in jail.
Let's go. What else we need to do?
Set me up for a bond here.
Okay, December 19th at 9 o'clock.
Okay, well, wait a minute. I ain't done yet. I still got some motions I want to file.
Okay, you can file them. Now, have you got copies for the state?
Yeah, I got copies for the state.
Okay,
too.
you need to provide I guess it's Mr. Ferrer.
Oh yeah, what about on my new case? Okay, on my new case. No. I never had a driver's license, right, in my life. And the fact that I'm charged with a felony is wrong. It's because driving without a valid driver's license is a misdemeanor, even if you're habitualized.
Hey, you need to file a motion.
Well, I got the motions ready right here.
Well, file it.
Okay, I'm about to file it. But my thing is, if it's already on the court's attention that the information that was filed on me was wrong, that's a fundamental error.
That's
impossible to charge.
This is unsworn testimony. I got no idea, but file your motion, and we've got everything. We'll set.
We already been through that because on my charge before, on my case before, you already corrected that charge. So why is?
Listen to me. I'm not arguing with you. This is a pretrial. I'll set your motions for December 19th. If you want to file your motions now and get everybody ready.
Right now, I'm filing. Okay. What about my Oh yeah, back to the representation thing that we had.
Okay.
Okay. I have a copy of my transcripts.
Yes, sir.
And you said that I expressly requested counsel. I got a copy of my transcripts to prove that that's not true.
Okay. Well, you on what case?
On my 23 case, I got a couple.
You represent
represent
yourself
me.
on that.
No, but you made me redo it. I had you
What is,
denied
what
all
is,
my
what is your,
motions.
what is your relief? What relief are you asking
My
for?
relief is that I want my motions to be heard that was denied
December
under Booker
19th.
versus State.
Look, we're gonna set the pre-trials for January 18th.
What I
January.
said, if you-
Listen, Mr. McCoy, you're hearing this over with today. I've listened to everything I'm gonna listen to. We'll set your motions. If you want to file them right now, give the state their copies December 19th at 9 o'clock for the motion. I'm assuming it's a motion to reinstate bond. It may be a motion to
It's a motion for
dismiss.
motion to discharge and a motion for notice.
All right, file them and we'll set it for December
Motion to
19th. We're gonna
dismiss.
set, we're gonna set everything for January 18th for
Let
a
me get my
pre-trial.
motions ready. I ain't ready to be pulled out yet. I gotta get a state.
No, sir, you can hand it to them, but this is, you're hearing over with today.
I can't get them my motions.
Yeah, that's got nothing to do with it.
All right, I gotta get them ready.
You just let Mr. Devontae McCoy sit in the courtroom and get his paperwork ready and let him file his motions and give his copies to the state.
You have a nice day, Mr. Clark.
Huh?
You have a nice day, sir.
You too, Mr. McCoy.
Have you ever wondered what happens when someone tries to bend the rules of the legal system to their advantage? When courtroom tactics clash with reality, the results can be both shocking and fascinating. Today, we dive deep into two extraordinary hearings that reveal just how far some people will go to avoid consequences, and how the legal system responds with patience, precision, and authority. The first case opens with a man facing an unimaginable reality, 2 life sentences. From the very start, it's clear he's not going to go quietly. He claims he cannot read, cannot write, and cannot understand the legal proceedings. He insists that the courtroom has no authority over him. He rejects the very foundations of the process, trying to convince the court that ignorance should somehow shield him from responsibility. His lawyer, doing everything possible to guide him, presents a 25-year plea deal, a chance to reduce decades of potential imprisonment. But the man refuses. He rejects any compromise, refuses to cooperate, and insists on representing himself. He believes clever arguments and theatrics might tip the scales in his favor. Yet, the courtroom is not a place for theatrics. The judge, calm but firm, makes it clear that self-representation will not be allowed. Rules are rules, and pretending ignorance does not change them. The trial moves forward despite the defendant's resistance. The tension in the room is palpable, as this man's attempts to manipulate the system collide head-on with procedure, authority, and reality. Each objection he raises, every feigned confusion, is met with reason, clarity, and structure. It's a demonstration that the legal system is designed not to be tricked, and that justice follows rules, not theatrics. Meanwhile, in another courtroom, a different defendant, Mr. McCoy, is trying a different approach, but the principle is the same. He repeatedly demands a bond hearing, even though his bond was previously revoked after committing another crime while out on release. He argues, questions, and challenges the court at every opportunity. He tries to convince the judge that persistence and repetition will work in his favor. Yet, the judge remains patient and unwavering, explaining that bond is not a right but a privilege. Laws exist for a reason, and repeated demands do not override prior decisions. No matter how many times he pushes, the verdict stands, the bond will not be reinstated. What's striking in both cases is the pattern. Individuals attempting to manipulate the court through feigned ignorance, repetition, or argumentation rarely succeed. These hearings illustrate the limits of courtroom strategy when it conflicts with reality. Whether it's rejecting plea deals, pretending not to understand, or continuously challenging decisions that have already been made, the legal system has mechanisms to maintain fairness, procedure, and order. Watching these hearings, it becomes clear that the courtroom is a place where patience, authority, and consistency are paramount. The judges act not with anger or frustration, but with steady enforcement of the law. Each decision, each denial, is delivered with reasoning that is both firm and precise. It's not about winning arguments in the moment, it's about ensuring justice follows procedure and consequences are enforced fairly. These hearings also reveal something deeper about human nature. People often believe that cleverness, persistence, or theatrics can allow them to evade responsibility. They try to manipulate, they try to delay, and they try to confuse. Yet, the courtroom is built to see through such tactics. Pretending not to know, refusing guidance, and repeatedly challenging settled matters does not alter reality. It only prolongs the inevitable. The first defendant, facing life sentences, learns the hard way that denial and defiance cannot overcome consequence. The second defendant, trying to reclaim bond through repetition, discovers that persistence alone cannot rewrite the rules. Both cases serve as vivid examples of how the legal system maintains its integrity. For viewer, these hearings are more than just legal proceedings. They are lessons in accountability, structure, and the limits of individual maneuvering. They illustrate that the law is not flexible in the face of feigned ignorance or endless argumentation. The courtroom operates on principles of fairness, not performance. The judge's patience and clarity are a masterclass in authority and enforcement. By the end of these hearings, one thing is clear: the courtroom is not a stage for games, and justice is not easily swayed. Ignorance is not a shield, persistence is not a loophole, and rejection of procedure does not change outcomes. The law is structured to ensure consistency, fairness, and consequence, and these hearings provide a stark reminder of that truth. Every objection, every attempt to delay or manipulate, only reinforces a simple reality: the legal system sees through pretense. The courtroom rewards clarity, adherence to rules, and cooperation, while ignoring or rejecting tactics built on deception, denial, or repetition. These cases highlight how authority functions when applied with patience, intelligence, and procedural discipline. The lessons here extend beyond the courtroom. They are cautionary tales about the limits of personal strategy in the face of structured systems. Whether in law, business, or life, attempting to circumvent rules through theatrics or feigned ignorance rarely succeeds. The legal system is a stark mirror of reality. Procedures exist for a reason, consequences are unavoidable, and accountability cannot be ignored. Watching these hearings, you see the interplay of human behavior and authority. The defendant's strategies fail not because of malice, but because systems are built to be resilient. Authority is patient but firm, consequences are inevitable, and reality is consistent. The courtroom, in essence, is a stage where truth and procedure ultimately prevail over manipulation and delay. In the end, these two hearings serve as a profound demonstration of justice in action. They show that the law is not a game, that authority is not arbitrary, and that persistence, denial, or theatrics cannot override structure. The courtroom enforces reality with precision, ensuring fairness and consequence, regardless of individual attempts to subvert it. For anyone watching, these hearings are both a cautionary tale and a lesson. They highlight the importance of understanding the system, respecting procedure, and recognizing that attempts to manipulate reality rarely work. The courtroom is a place of order, and these hearings remind us that, when faced with authority and structure, the truth cannot be ignored, denied, or repeated into oblivion.